Welcome, everyone, to 3 Ways to Plan Ahead for the Second Half of Life, sponsored by Safe Harbor Estate Law. We are so glad that you are here with us today. You're likely here because you want to live comfortably in the second half of life, and you don't want to leave a mess for your loved ones when you're gone. That's why I'm here too. If you're like many of our clients that we work with every day, you may be, again, worried about leaving a mess behind for your loved ones, like this train wreck, or you want to make sure that what you want to happen will happen if you get ill and when you die. And you may be concerned about what will happen if you end up spending all your money on long-term care needs. Or, like me, you may be concerned about your parents. I've worked together with my siblings to care for an elderly parent with dementia, and now we work together to support my elderly mom, as we did for my dad who passed with dementia in 2019. These are all valid concerns, and that's why we created this webinar. This is an educational program designed to address these questions and to empower you to do what is best for you and your loved ones. So before I show you specifically what you're going to learn today, I need to disclose that what I'm going to talk about applies generally to all of the states, but I'm going to focus specifically on Minnesota and Wisconsin. Also, this is not meant to be legal advice. It's educational because we don't yet have an established attorney-client relationship. However, before we wrap up today, you will have an opportunity to set a time to speak with a member of our team about your specific situation. So, with that in mind, here's our roadmap for the next 60 minutes with 3 stops. First, we're going to stop in what we call estate land. I know this may not be pleasant to think about, but in this land, we educate you on the legal documents and plan you need in place when you die. A stop in this land is critical if you want what you want to happen to actually happen after you pass away. And if you want your loved ones to still get together at the holidays. Because you have the right estate plan in place, you will not leave a mess for your heirs. I can tell after working with thousands of families, leaving a mess for them to clean up often causes tension and even rifts in relationships. Next, we will visit Medicaid asset protection land. Would you agree that one of the realities of life is that we age? And many people, as they age, become less able to care for themselves. Our team has worked with thousands of families, and one of the biggest concerns clients bring up is, what will happen to me if I can't care for myself? Will I be a burden on my kids? Will I get stuck in a nursing home? These are valid concerns if you do nothing. But the great news is you do have options. Most people don't know that, and few elder law attorneys are talking about this, which is why this webinar and the work we do is why we do this work, because we want to empower you. Finally, if you're like most of the people who attend this webinar, as we visit both lands, you'll likely be thinking, well, what about me in my situation? And you'll likely have questions that can only be addressed if our team sits down with you one-on-one. So don't worry, I'm not going to leave you hanging. Towards the end of the webinar, you'll have the opportunity to schedule a time for a private life and legacy session. Because the bottom line is this: if you act on what you learned today, you will not leave a mess for your loved ones, whether it's when you're still alive but needing care or after you pass. You can have the peace of mind knowing that you've taken care of yourself and those you hold dear. Now, before we dive in, I'd like to introduce myself. My name is Margaret Barrett. I was born and raised in East St. Paul. I am the 5th of 8 children, so you know that I learned early on how to negotiate. Here you can see me with my siblings and my mom. I am the founder and owner of Safe Harbor Estate Law, focused on helping clients just like you since 2013. I founded Safe Harbor 11 years ago, and I frequently present on estate and elder law issues. As a respected estate and elder law firm, we're members of the National Academy of Elder Law Attorneys, the Minnesota State Bar Association, Elder Law Section and Probate, and other professional groups. We have over 200 5-star Google ratings, which makes us the highest rated elder law firm in Minnesota. And we're the winner of the Law Firm 500 Award as one of the fastest growing law firms in North America for 5 years running. Most recently, we won the esteemed Best Places to Work Award in 2023, which highlights our positive culture that flows through from our employees to our clients. We now have a team of 17, and we're celebrating our 11-year anniversary this year. We do planning the right way, treating every client like we would want our parents treated. Our magic statement is, we empower you to protect what matters most. We focus on the 4 C's. We truly care, and it shows. We communicate thoroughly even after your plan is done. We stay in touch. We customize your plans. There's no cookie cutter planning here. And we create comprehensive plans, which you will hear more about today. I am proud of what we have achieved and the expertise and service we provide to our clients. But what our clients find equally important is, as our credentials, is why I started this firm. I will never forget how I woke up on Monday morning, March 10th, 1997. I was alarmed to hear the phone ringing before 6 a.m. I was instantly awake as I ran downstairs. My heart was beating, my mind was racing. I remember thinking, who's calling and what is the emergency? It was Barb, my sister-in-law. When I heard her voice, I immediately knew that something really bad had happened to my former husband, Joe. Barb said, Margaret, I don't know how to tell you this, but Joey died in a car accident last night. I was so shocked. He was already gone at age 39. It was too late for our children to say goodbye to their beloved dad. It was traumatic, scary, a life-defining moment. And if you've ever had an emergency knock at the door or phone call like that, you know what I mean. So next, I braced myself to wake my children, Ben, who was age 11, and Monica, who was age 9, to tell them that their father was gone. So much changed immediately for all of us. And for the next several years, much of my life revolved around walking Ben and Monica through the grief and all of the changes that come with losing a parent. To make matters worse, the estate was messy. To his credit, Joe had an estate plan, but there were 2 problems with the paperwork. First, it was not updated for the changes in his life. Common mistake. And second, it was drafted by a divorce attorney who did a little estate planning. We soon learned there was a critical mistake in the estate plan documents. So these 2 problems resulted in a lot of hassle, pain, and expense, and strained relationships. The legal battle lasted 7 years, and it went all the way to the Minnesota Supreme Court. So in addition to dealing with grief and loss, I walked my children through more than 7 years of estate litigation. I'm sure well over $100,000 in legal fees that could have been avoided or very minimized. I don't want anyone to go through what our family went through after Joe died. That is why I created the Smooth Sailing System. The system is designed to help you smoothly walk through our process of creating a comprehensive custom estate plan to protect what is most important to you. If Joe had gone through the Smooth Sailing System, his documents would have been up to date and properly prepared, and most of the hassle and expense would have been avoided. And in case it's not obvious, I wasn't Joe's attorney at the time. I wasn't even practicing that type of law at the time. So now that we've laid the groundwork, let's dive into the 3 ways to plan ahead for the second half of life. To help you understand the 3 ways, we will use 3 objects: the slide, the bucket, and the treasure chest. The slide and the bucket are part of estate planning land, and the treasure chest is part of Medicaid asset protection land. To help us navigate through both lands, I want you to meet Jim and Mary. Jim is 65, Mary's 63. They have 3 adult children, each married with children of their own. Jennifer is 44, and she's on Social Security income for a physical disability. Jason is 42. He at times struggles with chemical dependency and finances. And Jason is 40 years old and healthy. Jim and Mary have a $400,000 home in St. Paul, $250,000 in retirement, about the same in other investments, and they are blessed to own a cabin in Wisconsin that's worth $250,000. They have 2 cars, and they're currently living comfortably off their Social Security, a pension, and their retirement savings. The first stop in estate land for most people is what we call a will package, which we liken to a slide. Wills are basic, foundational estate planning tools that are helpful when you pass away. We use the illustration of a slide with wills because once the money is ready to distribute, then like going down a slide, it's a quick, fairly uncontrolled method of wealth transfer. Doesn't that sound great? In reality, the uncontrolled and immediate nature of a will could be a problem for many families. Gabrielle is sharing a poll now. Why might it be an issue for your heirs to get their inheritance all at once? Some of the ideas are they're minors, they have tax issues, they might spend it all at once, they could fight over my real estate, I only want them to spend it on certain things. So I'm going to stop a minute and watch the poll results, and we'll chat about that briefly. So most popular answer is they could fight over my real estate. That is very valid. That happens often. And if you have a will, there's definitely increased odds that make it easier to fight. They are minors also is a very good answer. Minors, if you leave money in a will, first of all, you're going to have a probate. The court's going to appoint a trustee who you don't get to pick, and the trustee gets to decide how the money's spent. And when they're only 18, they get all the money. Not what any of my clients ever wants. And taxes, yes, it can also affect taxes depending on your estate, and that is one of the effects. Another answer, they might spend it all at once, is also an issue. That's definitely a concern of some of our clients that some people who don't handle money as well will just go blow it rather than spending it the way their parents wanted them to. So I've seen all of those in my practice and more. So if you don't have a will, you may have heard the government has one for you, and you may not like the terms of the government's will. So you do need a will as a basic estate planning document. Let's look at some of the main reasons why you need a will. Some of the pros of a will are that it will get assets to the right people, the people you name, if all goes well. We'll talk about some of the times when it doesn't go well. Second, you may avoid probate with a will in the right circumstances with proper titling and beneficiary designations. And a will can work quickly, especially if you avoid probate. Now, some people are under the impression that having a will avoids probate. That is not true. Actually, wills are designed for probate. And what is probate? Let's define probate, because it is something most of our clients are worried about and want to avoid. Probate involves legal proceedings to gather, assess, and distribute assets after someone has passed. It is a public process. The public can find out how much you owned and where you want it to go, and your family will be hounded by solicitors. Probates are slow and expensive. They typically last at least 18 months and cost approximately $9,000 for a relatively simple case. So with probate defined, let's look at some of the potential pitfalls of a will. The first potential pitfall of a will is that the will controls less than you think. The will only controls assets that we say pass through the will. This means any accounts that are jointly held or have beneficiary designations, those pass outside the will and the will does not control them. So joint ownership and beneficiary designations both trump the will. For example, in their will, Jim and Mary could divide their estate equally between their 3 children. But if Jennifer is joint on one account, or if she's the beneficiary of the retirement account, she will own those accounts after they die, and she does not need to share them with her brothers, despite what the will says. Beneficiary designations can also go wrong. To demonstrate, I'll tell you a story about 4 daughters. A woman with 4 daughters died. 2 of her daughters came in and hired us to handle her estate. The mom had a certificate of deposit, and she had a proper beneficiary designation on it, dividing the certificate of deposit between her 4 daughters per stirpes, meaning if any of them predeceased, her 1/4 share would go to her children. Sadly, one daughter had predeceased her by a couple months, and another daughter died about a month after her. Under the fine print terms of the certificate of deposit, the daughter who died first was cut out as beneficiary, and her children received none of it. The other 3 daughters would each get a 1/3 share. This is not what our client wanted, and it's not what the beneficiary designation even said. Unfortunately, there was nothing we could do to fix it because the CD terms overrode the beneficiary designation, and so one daughter's children were cut off. So remember, joint ownership and beneficiary designations both trump the will. This is why, as part of the smooth sailing system, we not only create excellent documents, but we also give you clear written instructions on how each asset should be titled and exact beneficiary language. We want your assets to reinforce your will and work together with it rather than undermine it. Many attorneys do not provide this important part of a complete estate plan. Making sure your assets don't undermine your will or trust is part of our comprehensive smooth sailing plan. Okay, the second potential pitfall with the wills is that they don't allow you to add rules that add flexibility, control, and protection that you may want. For example, you cannot say, I want $40,000 to go to Susie for college, and if she doesn't go to college, to go to my church. Or you cannot say, if a child dies before me, I want their share to go to my grandchild in trust with this person as trustee, paid out on these terms, the balance to go to the child at 25 or 30. So there's many other examples of control and flexibility that you can't put into a will. The third pitfall involves the risks of specifically of selling real estate. So with real estate, if you only have a will, you are going to need to do a probate. Some people try to avoid this by using a transfer on death deed or TOD, but there are risks with TODs. All your heirs and their spouses are going to need to work together to sell the property, and they cannot use money from your estate to pay any of the property expenses. This can get tricky if people don't work well together or if money is tight. We can dive further into those risks with you in a one-on-one session, and we don't often recommend transfer and death deeds to our clients. In addition to the hassle with the transfer and death deed, the real estate may not go where you want, and no amount of hassle, time, or legal fees will likely fix it. For example, let's say Jennifer dies before Jim and Mary. Then there would be a probate again, even with a TOD and a will, and her share would likely go to her husband if she had one, or if not, then to her children outright. It won't go into a trust for the grandchildren, which is what Jim and Mary probably want. Finally, wills do nothing to protect against Medicaid or long-term care costs. We will dive into that later in the presentation. So regardless of who you work with, at a minimum, the documents that should be included in every will package are the following: the will, incapacity documents, which are the power of attorney, the healthcare directive, and the digital asset authorization. So type in the chat if you already have a will, and I'll check that in a minute. So if you do have a will, you're going to want to check to make sure these documents have been included in your package. Okay, so some of you have a will and some do not. Okay, because we at Safe Harbor have the 4 C's, one of which is comprehensive, we're going to include some ancillary documents such as a navigation plan, an asset summary, a digital asset organizer, a closing letter, instruction letters to your attorneys in fact, and a durable power of attorney if recommended. So you may have more documents. So let's look at what will happen if Jim and Mary only have a will plan. Let's assume Jim passes first since he is older. Everything goes outright to Mary. If they have less than $75,000 passing through the will, they can use an affidavit of collection that we could draft for them to access the accounts. This is much easier and quicker than a probate. When Mary dies, the remaining assets will go to the kids, mostly outside of probate if the titling and beneficiary designations are correct. Choosing a will would mean that Jim and Mary decided that they were not concerned about Jennifer keeping her Social Security benefits or Jason spending his inheritance wisely. There's no buffer to help Jennifer or Jason handle the inheritance well. Next, Jim and Mary would probably do a transfer and death deed on the house and the cabin to avoid probate in Minnesota and Wisconsin. Then the 3 children and their spouses will need to work together, share expenses, and agree on decisions such as cleaning out the home, listing it, and selling it. No one is designated in charge of the real estate, and no funds from the estate are available to help pay for the real estate. So hopefully the family will avoid probate and arguments with this strategy. So what could Jim and Mary do if they wanted to avoid the pitfalls of the will? Let's see how Jim and Mary fare with our second way to plan. That is creating what we call a trust. Have you heard the terms living or revocable trust? Those are the same thing. For the trust, we use the illustration of a bucket because it's going to carry your assets while you're alive and after you die. Since the bucket or the trust doesn't die, a probate is not typically needed. A properly designed trust bucket plan should contain the following. So again, please type in the chat if you have a trust. And these are the documents that we include in all of our trust packages. The trust, ours is approximately 70 pages because we want it to cover a lot of contingencies so that you don't have to come back later or have a probate unnecessarily. Certificate of trust, a pour-over will, a power of attorney, the healthcare directive, the digital asset authorization, a Minnesota deed, putting your real estate in trust, and an assignment of personal property. So if you have a trust, okay, so a few of you, we have someone who has a trust-based plan done, and most of you don't either have a will or no, not even a will. So if you do have a trust plan, check to see if all these documents are included. Now, let's look at some of the pros and potential considerations of a living trust, like we did for the will. The first pro is that there's more control, flexibility, and protection for you and your beneficiaries. All that conditional logic and sophistication that I said you can't put into a will, you can put into a trust. Second, trusts avoid probate if properly funded. Proper funding is key. So we help you with that, ensuring that your assets are titled right and your beneficiary designations are right. Third, a trust offers protection for your heirs from creditors, divorce, bad financial decisions, also from government programs. Definitely more protection. Now, if you have an estate larger than $3 million in Minnesota, and you may, once you really add up all your assets, your estate will pay estate taxes. If you're married and you choose a trust, we can put in language to double the estate tax exemption to $6 million, which could save you up to $400,000. What would your heirs do with an extra $400,000? Or let's say even $15,000 to $20,000. What could your heirs do if you saved them $15,000 to $20,000 by avoiding probate? Let us know in the chat, and I will check on your ideas. we have heard some really good ideas from some of our clients and some of our webinar attendees. What could you do? Is this a poll? No, this is a chat. Yes, it is a chat. Okay, so your heirs could use the money to pay down debt. That is a really great idea. They could use to save for retirement. They could go to Disney World. That's great. Family vacation. Wouldn't that be a nice memory healing time for your family? I like that idea a lot. Could buy a cabin. College tuition. Very good idea. Maybe a charitable donation. Yes. Reinvest for elder care. Wouldn't I love it if my kids would save their money so that they don't have to worry about their old age? That's a great idea. So thank you for the ideas. So definitely there can be a lot of value in the money that you save with the trust. So some more of the pros of a living trust are they're ideal if you lose capacity or need long-term care. And statistically, most of us will. One reason is that perfectly valid powers of attorney, which are important, but they're often not accepted by financial institutions. However, the same institutions will accept a certificate of trustee readily. Next, the trustee has immediate authority to sell property, distribute assets titled in the trust. They do not need to go to probate court to sell your real estate. The trustee has access to all the funds to pay bills, and this is much easier and quicker than probate or group decision making. Sixth, trusts are private. Wills are public once they're probated. So again, wills can entail solicitation, and anyone can find out on the internet how much money you have and who is getting what out of your estate. Some of the considerations with living trusts are they are more expensive now to draft, but they're less expensive than a probate. It's a pay more now, pay less later kind of a strategy. Some people honestly have sticker shock when they first hear the price of a trust, but they feel better as we discuss it being significantly less expensive than going through probate. Some people also come in saying, I would just like a simple will because I want everything to go really simple for my family. But the opposite is true. It's actually the more complex document that will make things go smoother and simpler. Another consideration with a living trust is that it does not protect assets from Medicaid and long-term care costs. For that, we will need to go to Medicaid Asset Protection Land to find the treasure chest. We will do that soon. So when it comes to a strategy for Jim and Mary with a trust, they would both serve as trustees now, dealing with the finances and business like normal. They would put non-retirement assets in the trust now, and retirement and insurance would go later. And that protects the accounts from being probated. They will have more protection and less hassle if they become incapacitated or ill. After death, the trustee can make a quick sale of the house and cabin with no probate. Or let's say the family wants to keep the cabin, they could create a cabin trust within the trust, spelling out the terms to help things work more smoothly for the family in the future in sharing the cabin. Fifth, their assets are going to be protected for Jennifer with her disability payments. She won't have to worry about being kicked off of Social Security and the inheritance basically going to the government. And they will be protected for Jason, who may not be making good financial decisions, and for the grandchildren in case a child predeceases. You could have a trust set up for them. In all, the trust is less work and less hassle for the family after Jim and Mary die than if they went through probate with a will. I hope you can see that while wills are a great first step, without a trust, you can often leave a large mess for your heirs. So now you've gotten the overview of what I call estate planning land, which is how to handle your assets when you die so your loved ones are set up for success. Let's dive into Medicaid Asset Protection Land. This is how you ensure that you still have assets to pass on to your loved ones and you have a quality of life while you're alive. There are many ways you can protect your assets, but today we are going to focus on the one that helps the average American with long-term care costs. So why should you care about long-term care? Think about your group of friends or your family. Once your group hits 65, 7 out of 10 of you will need long-term care. How does that make you feel? Gabrielle is sharing a poll now. Please select your guesses as to the average length of time people need care. I will take a look at your guesses and share the correct response on the next slide. Okay, there's some good answers here. So how long people need care on average? Some of you said 3 years. Some said 3 months, 4 years, and 6 months. Okay, let's go to the next slide. They're all good guesses. And of course, there's some people in all of those ranges, but statistics show right now the average is women need care an average of 3.75 years or 4 years. So 4 years is a good answer. Men average about a year less. So 3 years is another really good answer. Now, Gabrielle is sharing another poll. Select your guesses as to what you think long-term care costs per year. 200,000, 100,000, 50,000, 10,000, 5,000. It's kind of an average right now, which of course is always going up, not down. So everybody's answering 200,000 or 100,000. So this is a pretty well-educated crowd on this subject. So long-term care costs can exceed $200,000 per year in a nursing home. We definitely have clients in that range. In assisted living, about 125,000 is pretty typical, or in home care. So either 100,000 or 200,000, you all gave a good answer, I think. But I kind of plan for the 200,000 just to be conservative. So as you can calculate based on these numbers, the number of years you need care and the cost it can be, a single person can easily spend $1 million on care. That's why a lot of our clients are concerned. So don't despair, because there's a solution we've used successfully with over 500 clients, and we call it Medicaid Asset Protection Planning. Before we move on, I found that when I say the word Medicaid, people often have preconceived notions. So let's discuss that. In the chat, let me know what comes to mind when you hear the word Medicaid. And I will check on some of your answers so we can. Health insurance. So health insurance is a really good answer, because Medicaid, a large component of Medicaid is health insurance. So a lot of people under 65 who don't need long-term care, who have a lower income or have a disability, qualify for health insurance through Medicaid. That's a very good answer. The long-term care specific part of Medicaid is a separate part, there's various disability programs that I call alphabet soup. And they those provide additional services beyond just health insurance. That is part of it. I spend everything and I have nothing left. Yes, that's pretty much what happens if you don't do a plan with us. That's how you get on Medicaid long-term care, governed health care. Yes, that's a good comment. You do have some freedom with Medicaid. You can choose, like, for instance, what service is providing your care. If you're in your home, provided it's one that does Medicaid, that takes Medicaid, and where you live, provided it's one that takes Medicaid. So you do have some direction. It's not totally governed by the government, and can't afford insurance. So yes, again, that gets back to the health cares for people that can't afford insurance. And the part I'm focusing on today is the part that you can't afford to pay for long-term care, or you don't want to spend all your money in long-term care. So thank you for bringing that up. Sometimes I think people feel like it may be a little shameful to be on Medicaid, but this, again, is money that we paid tax dollars for, and similar kind of to Social Security. And so if you're eligible and follow the rules, you are entitled to have Medicaid, have the government help you pay for your long-term care. So if you don't want to spend all your money on care and you want the government to pay its fair share, then a Medicaid asset protection plan can get you there. Now, that's why we call it a treasure chest. It allows you to keep some of the treasure you've worked your whole life to create to benefit you and your loved ones. But to access the treasure chest, you need to follow the Medicaid rules, and there are large hooks to watch out for. Medicaid has complex rules that are not always well defined, and the way they interpret them evolves. Second, the rules are inconsistent and arbitrarily applied. The 83 different counties apply them differently. The workers in the county apply them differently, and over time they apply them differently. It's super important to really have an expert on the law on your side when you're working with the counties who knows the law better than they do. So to show you how backwards the system is, listen to this. Medicaid will allow you to spend $100,000 gambling at Mystic Lake, no problem. But they will not allow you to gift your grandchildren. Say you have 10 grandchildren, you want to give them $10,000 each for college tuition. For that, you get a penalty. Like I said, many of these rules are not what you would expect. So the truth is, without legal help, you can not only go broke paying for care, but also then you could apply for Medicaid broke and get denied because you unknowingly broke the rules along the way. And that, yes, it can cause you to get kicked out of a facility. It happens. So for all these reasons and more, Medicaid asset protection planning is very important and effective to both save you money and ensure that you get good care and follow the complex Medicaid rules so that you and your family have peace of mind. So Medicaid will pay for long-term care in a nursing home or in your own home, including assisted living, if you meet the requirements. So you might be thinking, what are the requirements? How do I get the government to pay for my care? The 3 requirements for Medicaid eligibility are the asset test, the medical need test, and the income test. So the one requirement we spend the most time strategizing and planning for is the asset test. So let's do a poll. How much money do you think you can have and still qualify for Medicaid? So our options we're giving you are $148,000, $3,000, $21,000, $2,000, and $255,000. So our answers are kind of all over the board. They're great answers. And nobody picked $255,000 because you knew that it wouldn't be the highest amount. Minnesota is not going to let you keep that much money. And the rules are slightly different in Wisconsin. So the 2 most correct answers, because they were all chosen except $255,000, is $3,000. If you're single, you have to spend down to only $3,000. And by the way, when you're on Medicaid, you only get about $120 a month of your income that you get to keep. So this is not a lot of money. If you're married, your spouse can keep an additional $148,620. So $148,000 is another good answer. However, a lot of times the surviving spouse lives another 10, 20 years or even longer, and $148,000 isn't actually a lot for them. So let's try this poll. Do you think you can have a house or a car and still qualify for Medicaid? Wow, everybody's saying you can have both. Again, I have a really well-educated group today. The answer is you can have both a house if you or your spouse are still living in it. That's generally the rule. A car if you're driven in it at least once a month, even if you can't drive, and a funeral policy besides. That fits the Medicaid rules. Those are the basic asset rules. Now, how you spend your money down from what you have now to qualify for these rules is based on complicated rules. One thing to watch out for between now and then, between today and qualifying for Medicaid, is that there's a look back period. So put in the chat if you've ever heard of the look back period and how long you think it is. So you must follow the Medicaid rules during the look back period, even though you don't know what they are. And the look back period is 5 years. Again, these rules are often contrary to what you would guess. I'm real interested in how you guys know these answers so well. You're right, 5 years. 7 years, one person plus 7. I will say in Minnesota, the legislature has talked off and on for years about increasing it to 10 years from 5 to 10 years. And when they do that, they're not planning to do any grandfathering in. It's like suddenly we're supposed to follow up the rules for an additional 5 years. So very good to plan ahead. So most of us think that good parents give good gifts to your children. This is biblical. But if you do that in the 5-year look back period, Medicaid imposes a penalty, meaning they're not going to pay for your care until the penalty is paid. And you may already be down to $3,000 at that point because you were trying to follow the rules. If you've given gifts already, don't worry, because if you still have sufficient funds left, we can make an asset protection plan for you to cover the gifts and avoid the penalty. I want you to avoid the horrible situation of needing to have your kids pay for your care, or needing to spend your spouse's $148,000, or getting kicked out of the facility and losing care. I want to help you have peace of mind that that is not going to happen to you, like we have seen it happen to others who did not have an asset protection plan and came to us in crisis. So by pre-planning with a Medicaid asset protection plan, we can help you, again, follow the rules, protect your assets legally, and ensure you get good care. So some of the pros are that all of your money doesn't go for care, and you'll still get quality care. The complicated changing Medicaid rules are followed, and the state pays their share of your care sooner. You pay less and they pay more. Our clients typically protect 50 to 80% of the assets that they would otherwise spend down to $3,000. This reduces stress and workload for you and your family, very much so. It's not fun to work with Medicaid, and we will take that burden off of you. So the potential pitfalls of an asset protection plan are that the largest dollar savings require you to have a trusted family member, or could be friends, to hold large gifts for your benefit. So you're going to make a gift to somebody who's going to hold the money for your benefit that you can trust, and they're not going to go spend it all in Vegas. Secondly, a pitfall is this is not a do-it-yourself. I have seen people go into care and have the nursing home offer to fill out the Medicaid application for free, after you spent $400,000 on care at the nursing home. That can quickly become a nightmare. I've seen people attempt to fill out the forms on their own, and that has become a disaster. You need to receive legal advice from an elder law lawyer. The truth be told, there's fantastic lawyers in Minnesota and Wisconsin, but our recipe for an asset protection plan is not only the best I have seen, it is cutting edge. We have seen attorneys time and time again recommend that the client should just spend all your money down to $3,000. But you want to work with an attorney like us who is using all the tools and resources available to best protect you and your wealth. And that is exactly what we do best. So working with an elder law attorney experienced with all the planning tools is essential to help you get the full benefit of an asset protection plan. We say that we use all the tools in the tool chest to help our clients legally protect assets and get good care. Two of the main tools I'll be talking about are Medicaid compliant annuities and Medicaid asset protection trusts. There are many other tools available depending on our clients' goals and situations. So the first asset protection tool is a Medicaid compliant annuity. This is the tool we use the most often to save 50 to 80% of our clients' assets if they qualify for it. I'm going to give an example of the first client I helped with an annuity about 6 years ago. He had a stroke in his early 60s and would be in a nursing home for the rest of his life. He had approximately $600,000, and his sister and his son were afraid that all of that would be spent on his care, except, of course, for the $3,000 Medicaid allowed him to keep. At that point, with our help, he could apply for Medicaid and have the state pay the rest of his care. If you don't have a Medicaid asset protection plan, like the vast majority of people don't, then this is your plan. Spend down to $3,000. Let's see how a Medicaid asset protection plan can change this picture. So instead of spending all his money on care, this client hired us to do a Medicaid compliant annuity plan. He was able to give over $300,000 to his devoted son, that was his trusted person, to hold for his benefit if needed. Then we helped him buy a Medicaid compliant annuity in the right amount with the additional $297,000. That's the care cost section. He applied for Medicaid that very month instead of waiting a few years till he spent all his money. We disclosed that we made a gift during the 5-year look back period. We gave the son $300,000 last week. So the county imposed a penalty and said, we're not going to pay for any of your care for 3 years. You have to pay it. That didn't bother us at all. We bought the annuity designed to pay for the care for 3 years. We pre-calculated the penalty. At the end of the 3 years, the annuity was done, and Medicaid has been paying ever since. His son still has most of the $300,000 gift, and the family is very grateful and relieved. I know this is a common scenario because we have made asset protection plans like this over 200 times in the last year. So this is what you should remember about Medicaid compliant annuities. First, remember that this kind of annuity provides the monthly payments to your checking account so that you can pay for care during the penalty period. This is not the typical annuity you may have heard about from your financial advisor. This one you must work with an elder law attorney to benefit from. Here's some other important things to remember. Medicaid compliant annuities are new in Minnesota, and they are game changers. You can save 50 to 80% of your assets with a proper plan and still get good care. You make a gift to trustworthy persons, that's key. And the sooner you plan, the more you save. Our Life and Legacy session will help you assess if you're a good candidate for an asset protection plan. The next new tool, brand new tool, is a Medicaid Asset Protection Trust. Now, you were probably familiar with the terms will and trust before this presentation, but most people are unfamiliar with the Medicaid Asset Protection Tool. This type of irrevocable trust has been used for years in the other 49 states, including Wisconsin. In Minnesota, this tool has only been allowed since July of 2021 when the Minnesota Court of Appeals issued the Guyan decision. Our lead attorney for Medicaid, Michael Teeter, wrote part of the winning brief, arguing that Minnesota's disallowance of the Medicaid Asset Protection Trust was unconstitutional. And happily, the Court of Appeals agreed. So now you can do a Medicaid Asset Protection Trust just like all the other Americans. Let's look at a sample asset protection plan for Jim and Mary. And this will include the sample of how to use a Medicaid Asset Protection Trust, which is kind of similar to a Medicaid compliant annuity. So they're planning ahead. They're not paying for care yet. So they think they have 5 years. So they could take their cabin and say $100,000 to cover cabin expenses and put it in a Medicaid Asset Protection Trust with their children in charge of and benefiting from the trust. We would update their estate plan documents to include what we call super gifting powers so that if they lose capacity in the future, we could still do a Medicaid compliant annuity. Now, if they don't need care for 60 months, 5 years, then the assets in the Medicaid Asset Protection Trust are protected from Medicaid. Now, once Jim or Mary starts needing care, we could now use the Medicaid compliant annuity strategy to protect another 50% of the remaining assets, say another $400,000. And then the penalty period that would be imposed for that would be covered by a Medicaid compliant annuity. So they could potentially use both of those tools. And there's even more tools I'm not going into they could use, but these are the biggest ones. Then during life, with the $400,000 gift to the children could gift assets back to Jim and Mary to ensure that they continue to get good care until they're gone, and then divide the funds up the way Jim and Mary want after they die. So now you have been introduced to the slide, the bucket, and the treasure chest. I want you to remember these key takeaways. It is best to plan ahead for death and illness, for sure. You have more control and flexibility and peace of mind if you do. If you're over 50, you not only need a good estate planning lawyer, you also need an estate planning lawyer who is an elder law attorney. Not all estate planning lawyers are elder law attorneys, especially elder law attorneys that use all the tools to protect for Medicaid asset protection. Be sure to ask. Lastly, I would say now is the best time to act. And we would love to help you. We helped over 200 estate planning clients last year and 173 Medicaid asset protection clients. And at the beginning of this webinar, I promised we wouldn't leave you hanging wondering, what do I do next? If you would like to get started on putting your plan in place, I'd like to offer you a private, smooth sailing life and legacy session with a member of our team. This is a 90-minute session in our office. In this session, we will accomplish 4 things. We will get clarity on what is important to you. From this, you'll be able to make important decisions on how you want your estate handled should you need care and when you die. You'll discover whether a will or a trust plan will best meet your goals. And if you already have one or the other, what the gaps are in your current plan, if any. You'll discover if you'll benefit from a Medicaid asset protection plan, and if so, what's the best time to act. And lastly, you'll leave understanding how our smooth sailing process works and how we can get you from where you are now to where you want to be. So many clients leave this session feeling empowered and cared for, and that's one of our main priorities. So here's a recent review from one of our clients you can read. Now, I'm going to walk you through how to register for your session. Typically, there's a reservation deposit of $150, but because you're here today, I know you're serious about not wanting to leave a mess, and we want to honor that and give you $50 off the deposit. So it's $100 to hold your reservation just if you schedule today. So first, click on the Schedule Your Discounted Appointment with Nate button at the bottom left of your screen. Have you all clicked? Like I said, I'm going to follow along with you. Good. Okay, then it will take you to this page. So click on the Life and Legacy Session in Office option with the blue dot. And you should now see all of Nate's appointment availability. So I can see, just click on any of the days that is available and you will see the open times. So I am going to pick one myself. Pick one that works for you. Remember, we leave an hour and a half for these meetings. So we want to make sure we address all your concerns. Next, the form will have you put in your contact information. My name and email is auto-filling. I'll put in my phone. And I am booking for me. You need to put answers in each of these boxes or it won't go forward. And then the services, I'll say, I want to trust. Or that's what I'm thinking right now. And then you need to click the box that says, I understand there's a session fee and my appointment won't be saved unless I actually follow through and pay the session fee. So then we click schedule the event on the bottom there. It doesn't show on the screen, but it's right there. And next we have the payment slide. So now you can fill out your contact information again. You can say webinar for who referred you, first and last name. I said I was going to do this along with you, so let me do that to give you time. Otherwise, this won't be as helpful to you, and I want it to be helpful. So, because there are a few steps here. So I'm putting in my email. I did my name, my phone number, my email. The card that I'm going to pay my discounted amount to, you can do your bank account if you don't use a card. There's also an option for a loan, but I don't think you need to do that for $100, hopefully. Okay, so I'm filling in the card information and my address. Okay. I am going to use my autofill here that is filling it in, which you may or may not have. So that made it quicker for me. And then I just hit pay. You can also do e-check. So pay $100. Okay. And once you do that, that's it. You did it. You will receive a confirmation email from the calendar confirming the appointment. And you can RSVP to add the event to your own personal calendar automatically. And then keep in mind, you're going to get automatic notices for any changes to the appointment, as well as reminders as the date gets closer, directions to our office. And you may get separate emails from our staff here. They will all come from emails ending in @safeharborostatelaw.com. So don't be surprised. And for sure, Gabrielle will call you within 48 hours to touch base. We do this because we know this can be a difficult topic, and we want you to feel as comfortable as possible when you come into our office. We also want to make sure that the booking confirmed and that you're receiving the necessary communications. This is the number that Gabrielle will be calling from. We want to thank you again for being here today and taking time out of your day. I want to close with this idea from Napoleon Hill. Don't wait. The time will never be just right. Thank you so much for joining us. When you work with us, we will ensure you sail as smoothly as possible into the second half of your life. And we look forward to seeing you in your life and legacy session. Thank you so much, and have a great day.